Hello and welcome to my presentation. My name is Lorenzo Crippa. I'm a first-year PhD student from the Department of Government at the University of Essex, and I'm going to present my first paper for my PhD thesis, the Conditional Arm of International Law, that studies the effect of the OECD Anti-Bribery Convention on foreign direct investment. Let me first introduce you the puzzle that motivates the paper. So, in political economy, we've seen a large wave of international economic agreements that until the 1980s, more or less, emphasized the retreat of states from international markets. And I'm thinking about negotiations, rounds of negotiations, such as the General Agreement on Trade and Tariffs, which had to remove, for instance, tariffs and similar trade barriers in order to favor international markets. And this has generated a prolific debate in international political economy on the winners and losers of these agreements. But in the past 3 decades, we've actually seen a surge in agreements that require states to intervene in international markets in order to prohibit illicit or undesired behaviors such as trusts, violation of intellectual property, money laundering, or corruption. And my question is, do these agreements matter to privates? And if so, have privates benefited or suffered from them? And in order to show you that this is not obvious, I'm going to introduce the case that I focus on. I consider the OECD Anti-Bribery Convention that was ratified in 1997. It is an agreement whereby signatory countries have decided to make it a crime, to make it a criminal offense for their firms to pay a bribe in a foreign jurisdiction, so to bribe in international business transactions. And it wasn't the case before this agreement was signed. It wasn't a criminal offense for firms to pay bribes in international business, and it still is not a case in countries that have not ratified it. Nowadays, the agreement counts 44 signatories, which are home to 81% of global outbound of investment. So, to me, the question becomes, how important has the OECD Anti-Bribery Convention been for investments of these firms, given that such a large share of global investments now fall under the umbrella of these regulations? Of course, costs of bribing abroad have increased to firms. This is rather obvious, because parent firms are now held accountable for the conduct or misconduct of their foreign branches. And they have to pay blockbuster fines or monetary settlements when these branches pay bribes. And we have evidence, of course, that bribery has decreased as a result of these regulations. So in a way, we know that these institutions matter. But we also know the benefits have increased to firms that come from countries that have ratified this convention. After all, corruption imposes a cost on business. It works similarly to a tax. And having anti-bribery rules means having the chance to refuse paying bribes, because you can always say, I can't, my hands are tied, I can't pay this bribe because I'm going to be prosecuted back home. So my question becomes, what effect has adoption of the OECD Convention had for firms from signatory countries, and in particular for their investments? My argument states that this effect is conditional on the host country corruption. And let's see why this is the case. First of all, we need to think about what investing under the OECD Convention means. In political economy, we refer to FDI, foreign direct investment, as a transaction whereby a firm from a country X acquires a significant share of another firm from a country Y. And in particular, this transaction is made for productive reasons, not for speculative reasons. Within this family of foreign direct investments is subsidiary incorporation, whereby the firm from country X decides to wholly own, to wholly acquire the controlled subsidiary from country Y. Subsidiary incorporation is a strong commitment to a foreign economy and entails a long-term assessment of risks and benefits. Under the OECD Convention, firms are held accountable for the misconduct of their subsidiaries, even for behaviors that predate incorporation. To take a very recent example, at the end of past June, the pharmaceutical company Novartis AG from Switzerland has agreed to pay $347 million to US prosecutors for a scandal that involved its subsidiaries in Greece, Vietnam, and South Korea. We know that institutions provide information, credible information, to firms that regularize their long-term expectations, that make the future more foreseeable in a way. So the terms of the OECD Convention enter into the long-term evaluation that firms make when they decide whether to incorporate a subsidiary or to invest. And in particular, firms from signatories to the OECD Convention will definitely incur indirect costs in case of bribery, because they are imposed penalties and monetary settlements if them or their subsidiaries are found guilty. They have to abide by costly and compulsory reorganization of their corporational structure to ensure future compliance with anti-bribery standards. In particular, this is particularly true for cases that are brought by US prosecutors. And also the market imposes reputational penalties on these firms. In the case of anti-bribery, they account for 80% of each dollar lost after a corruption scandal. So it's a very large share. At the same time, anti-bribery rules also represent an asset, because they provide to firms the possibility to leverage on them to refuse the request of bribes by foreign corrupt officials, as argued by the Peace of Davis from 2019. The two pools alter firms' expectations in opposite directions. The first one represents a cost, the second one represents an asset, a benefit. And the net effect of adopting the OECD Convention on firms' foreign business will depend on the relative strength of these two pools. My argument is that the relative strength depends on the host level corruption, on the corruption of the host country. In host countries where corruption is not deep-rooted, where it's not endemic, well, firms from signatory countries will not face a different cost-benefit setup than firms from non-signatory countries, because neither group will have most likely to pay any bribe. As the host country gets more corrupt, anti-bribery standards become a valuable asset, because firms can leverage on them to refuse paying bribes. But as the host country becomes extremely corrupt, benefits of anti-bribery laws become weaker and weaker and weaker, because the power of corrupt public officials increases, and we know that in very corrupt countries, public officials have the power to demand a bribe. At the same time, and this is true for both, it's true for signatory and non-signatory countries, of course. At the same time, firms from signatory countries will expect higher costs, because they are doing business in very corrupt countries, and they will be prosecuted for bribe if they're found guilty. And firms from non-signatory countries do not face the same cost. So my expectation is that the net effect of adopting the OECD Convention on the probability of investing abroad will be conditional on the level of corruption of the host country, but in a non-linear way. And I'm going to show you the empirical analysis which I used to test for this argument. I decide to model as a dependent variable decisions of firms to incorporate a subsidiary in a host country, because it's a very strong commitment to the host economy. I used the database retrieved from an article by Beezer and Blake in HAPS from 2018. The data come from Orbis Corporate Ownership. It's a cross-sectional database on decisions by 3,781 firms from 56 different countries to incorporate a subsidiary abroad between 2006 and 2011. I used the exact same binary dependent variable that they use for each firm. I model whether the firm has set up a subsidiary in a foreign host country or not, and I assign a 1 or a 0 accordingly. So the dataset is structured in a dyadic way. Each firm is nested in a home country, is investing in a host country, and each observation is basically a dyad at the firm level. Potential host countries are all those where at least one firm has set up at least one subsidiary in that period, which makes for a total of 105 potential host countries. By doing this, I assume that I'm able to capture all attractive host countries and to rule out countries which are not attractive. My main explanatory variables are two. The first one is OECD signatory and takes value 1 for home countries that have ratified the convention by 2005, because my cross-section starts in 2006, And I consider the entry into force of the convention, which means having the actual legislation, the actual piece of legislation, of anti-bribery legislation. And the second explanatory variable that I'm interested in is corruption, which measures the level of host country corruption. I intend to avoid perception-based indexes of corruption, such as the Corruption Perception Index from Transparency International, because they are holistic. They capture very, very different aspects, institutional aspects of the host country, and they risk being biased because of being perception based. There's a huge literature in corruption studies on this. So I decided to use the Public Administration Corruption Index by Escresa and Picci, the PACI. The PACI measures the degree by which the number of observed cases of cross-border bribery diverge from the number that could be expected based on trade flows. So it relies on objective information on cases of bribery and not on subjective perception-based indexes. So I mostly employed this measure to indeed to measure host country corruption, but I also test if my results are robust to the use of perception-based indexes, even though I know like they could be flawed. And for doing that, I use the 2005 value of the World Bank Control of Corruption Estimate, the CCE. So my model specification is a multi-level logit model that explains my dependent variable. In the model, I condition OECD signatory on the linear and squared values of host country corruption in order to capture my argument about the nonlinear conditional effect of having ratified the OECD Convention on the probability of investing abroad. And in the model, I control for unobserved heterogeneity, including random intercepts at the level of the host country, the dyad, and industry level too. But I also control for a bunch of covariates, of course, which you see listed here. I control for economic characteristics of home and host country, for institutional confounders, for dyadic features, and for firm level attributes. These are pretty much standard in the literature on foreign direct investment, and I have reasons to believe that they could confound my estimation of the effect of the conditional effect of ratifying the OECD Convention on the probability of investing abroad. So here are the results of my models in a coefficient plot. So first of all, I show you that the effect of having ratified the OECD Convention on the probability of investing abroad unconditionally on the level of corruption of the host country is not significant. You can see it in red. You can see that the coefficient is not statistically different from 0. But when I introduce the interaction term with the linear and squared value of host country corruption, you see the models in yellow and green. The coefficients with the interaction terms, the coefficients associated with the interaction terms become significant. The coefficient with the squared interaction term is negative in sign, and the other one is positive in sign. They're both statistically significant at the 99% confidence, sorry, at the 1% level of significance. And this is true even if I include controls in the green. You can see it in the green dot. And this is true also when I use the alternative measure of corruption, the host country control of corruption estimate. An interesting result here is that the effect of corruption is never statistically significant from statistically different from 0, which to me suggests that corruption is not a determinant per se of the probability of investing, but it's more the possibility of being prosecuted, captured by coming from a ratifier of the OECD Convention that justifies that determines investments. And let's take a look at the way at the marginal effect of ratifying the OECD Convention on foreign direct investment. Here you see the effect that coming from a signatory of the OECD Convention contributes to the probability of investing abroad conditional on the level of corruption of the host country, measured by the PACI index. You see that for very, very clean countries, on the left-hand side of the x-axis, the effect is small and statistically indistinguishable from zero. Then it starts growing and it becomes positive for mildly corrupt countries as the host country corruption increases. And I argue that this is because here firms can leverage on having anti-bribery rules to refuse paying bribes, and so here anti-bribery rules represent an asset. But then the effect reaches a peak and then starts decreasing again, and it decreases until it becomes even negative and statistically significant for very, very corrupt countries. Here the asset that were that anti-bribery rules were before is no longer in place. And having anti-bribery rules means just having a price to pay, because the risk of having to pay bribes and being prosecuted is very, very high. So for firms active in very, very corrupt countries, having ratified the OECD Convention is an actual cost. I can show you this with this graph. I show you that the marginal effect is basically the same when we use the host country control of corruption estimate. Here the x-axis is basically flipped, because on the left hand we have very, very clean countries, very, very corrupt countries, and on the right hand we have very, very clean countries. So it's basically flipped, but the interpretation is exactly the same. And we see that for very, very corrupt countries, as before, the coming from a ratifier of the OECD Convention decreases the probability of investing by 50%. To conclude, of these, to draw some main takeaways from these from this study, which is still a work in progress, is that so ratifying the OECD Convention has an effect on firms' decisions to incorporate a subsidiary. And the direction of this effect is non-linearly conditional on host country corruption, which tells us that the effect of international institutions is not constant across jurisdictions. Economic international agreements have different effects, even when they engage markets. But the effect is market specific. This is something that I haven't shown in the presentation for the sake of brevity, but in a different models I show that firms from industries that are not typically involved in bribery have not suffered the consequences of the mechanism that I identify, whereas firms from industries that typically pay bribes, that are typically involved in bribe payments, have suffered it. Which tells us that the industries respond differently to international institutions based on the practices, on the common practices that characterize them. So the next steps in this work in progress is basically what I summarize here. So if my argument is correct, then it should also hold when looking at dyadic country-level FDI stocks, and I intend to test this argument with a difference in differences model in order to estimate a cleaner causal effect and to test the robustness of my results. I thank you for your attention. I look forward to all your comments, and here's my email.